I'd like each one of you to take a couple of minutes to run through what you think the key takeaways are that people should leave today's webinar with. And Anna, why don't we start with you this time?
Okay. I think one key takeaway I would want everyone to have is that as much as we might like for this to be so, you don't have to have epidemiology. And if there's nothing else I leave you with, it is this. We all, on the defense side, we in particular, we tend to be enamored with epidemiology. And I stand behind the statement that it is, in fact, the gold standard. But don't assume that the absence of epidemiology is necessarily going to be your friend. It may, in fact, complicate matters a bit further. And then the other thing I think to be forewarned about, and it relates to also knowing your judge, is know if your judge is the type of judge who is going to be heavily influenced by an expert's credentials, particularly in a circumstance where you're dealing with a rare disease. If credentials matter, consider that when you're picking your own experts. If nothing else, it may buy you a little bit of favor with the court.
Thank you, Anna Pichelle of Alston and Bird. Now let's turn the same question over to Paul Wasicki. Paul?
Well, I would add on to what Anna said about knowing your judge. I'd say also know your circuit, because different circuits certainly have a different approach. And you may have a trial court judge that's a little bit tougher in a circuit that is a little bit more open to letting in weak but shaky expert testimony. So build your motion accordingly. I think Anna's point about don't give up, don't take anything as unwinnable is important, because science marches on and things change frequently and rapidly, and don't be afraid to take a fresh look at what seems like a fairly settled issue. And two more points. One, the devil is in the details. Really closely examine where the expert is coming from, whether it's your expert or your opponent's expert, and make sure that all the I's are dotted, T's are crossed, that in fact they've built, constructed, fabricated a very strong chain of reasoning and logic. And finally, don't forget the policy reasons underlying the rule and the interpretation of the rule in Daubert and the cases after that. Again, the end goal here is to protect the integrity of the judicial process, and that's an important point to be made and reiterated, especially when you're dealing with testimony that is borderline or is more than merely shaky.